Welcome back to the channel where currently I am lecturing about the incorporation of a company, and in today's lecture I am going to talk about Memorandum of Association, that is MOA. I have already covered this topic earlier, but here in this video lecture I am going to go more in detail of it. So do watch the lecture till the end. So let's start with the lecture. Memorandum of Association. A company is formed when a number of people come together for achieving a specific purpose. This purpose is usually commercial in nature. Companies are generally formed to earn profit from business activities. To incorporate a company, an application has to be filed with the ROC. This application is required to be submitted with a number of documents. One such of the fundamental documents that are required is the MOA. Definition of MOA. Section 2, Clause 56 of the Companies Act 2013 defines Memorandum of Association. It states that a memorandum means two things. First, Memorandum of Association as originally framed. Originally framed refers to the memorandum as it was during the incorporation of the company. Second, memorandum as altered from time to time. This means that all the alterations that are made in the memorandum from time to time will also be a part of MOA. The section also states that the alterations must be made in pursuance of any previous company law or the present act. In addition to this, according to section 399 of the Companies Act 2013, any person can inspect any document filed with the registrar in pursuance of the provisions of the act. Hence, any person who wants to deal with the company can know about the company through the Memorandum of Association. Meaning of Memorandum of Association. MOA is a legal document which describes the purpose for which the company is formed. It defines the powers of the company and the conditions under which it operates. It is a document that contains all the lectures, rules, and regulations that govern a company's relations with the outside world. It is mandatory for every company to have a MOA which defines the scope of its operations. Once prepared, the company cannot operate beyond the scope of the document. If the company goes beyond the scope, then the action will be considered ultra vires and hence will be void. It is the foundation on which the company is made. The entire structure of the company is detailed in the MOA. The memorandum is a public document. Thus, if a person wants to enter into any contract with the company, all he has to do is pay the required fees to the ROC and obtain the MOA. Through the MOA, he will get all the details of the company. It is the duty of the person who indulges in any transactions with the company to know about its memorandum. Now, object of registering a Memorandum of Association. Memorandum of Association is an essential document that contains all the details of the company. It governs the relationship between the company and its stakeholders. Section 3 of the Companies Act 2013 describes the importance of memorandum by stating that for registering a company, first, in case of a public company, 7 or more people are required. Second, in case of private company, 2 or more people are required. Third, in case of one person company, only one person is required. In all the above cases, the concerned people should first subscribe to a memorandum before registering the company with the registrar. Thus, MOA is essential for registration of a company. Section 7 Clause 1 Subclause A of the Act states that for incorporation of a company, MOA and AOA of the company should be duly signed by the subscribers and filed with the registrar. In addition to this, a memorandum has other objects as well. These are: first, it allows the shareholders to know about the company before buying its shares. This helps the shareholders determine how much capital will they invest in the company. Second, it provides information to all the stakeholders who are willing to associate with the company in any way. Format of Memorandum of Association. Section 4 Clause 5 of the Companies Act states that a memorandum should be in any form as given in tables A, B, C, D, and E of Schedule 1. The tables are of different kinds because of different kinds of company. Table A, it is applicable to a company limited by shares. Table B is applicable to a company limited by guarantee and not having a share capital. Table C is applicable to a company limited by guarantee and having a share capital. Table D, it is applicable to an unlimited company and not having share capital. Table E, it is applicable to an unlimited company having a share capital. Now let's talk about content of Memorandum of Association. Section 4 of the Companies Act 2013 states the contents of the memorandum. It details all the essential information that the memorandum should contain. Firstly, the name clause. The first clause states the name of the company. Any name can be chosen for the company, but there are certain conditions that need to be complied with. Section 4 Clause 1 Subclause A states, if a company is a public company, then the word limited should be there in the name. If a company is a private company, then private limited should be there in the name. This condition is not applicable to Section 8 companies. So the question arises, which are the Section 8 companies? Section 8 company is named after Section 8 of the Companies Act 2013. It describes companies which are established to promote commerce, art, sports, education, research, social welfare, religion, etc. Section 8 companies are similar to trusts and societies, but they have a better recognition of legal standing than trusts and societies. So, what kind of names are not allowed? The name stated in the memorandum shall not be identical to the name of another company, too nearly resembling the name of an existing company. According to Rule 8 of the Company Incorporation Rules 2014, if a company adds limited, private limited, LLP, company, corporation, or corp, or INC, and any other kind of designation to its name to differentiate it from the name of the other company, the name would still not be accepted. If plural or singular forms are added to differentiate between names. Illustration: green text solution is same as green text solution in capitals or in small letters. If type and case of letters or punctuation marks are added, different tenses are used in names. If there is an intentional spelling mistake in the name of phonetic or phonetic changes in the name. Internet related designations are used like .org, .com, etc. Under this, there is an exception. The name will not be disregarded if the existing company by a board of resolution allows it. Next, change in order of combination of words. Under this, the exception is the name will not be disregarded if the existing company by a board of resolution allows it. Addition of a definite or indefinite article. It has the same exception as the earlier case. Slight variation in spelling of two names, including a grammatical variation. Translation of a name from one language to another. Addition of the name of a place to the name. This point also has the same exception as the earlier points had. Addition, deletion, or modification of numericals in the name. In addition to this, an undesirable name will also not be allowed to be chosen. Undesirable names are those names which, in the opinion of the central government, are first, prohibited under provisions of Section 3 of the Emblems and Names Prevention and Improper Use Act 1950. Second, names which resemble each other, which are chosen to deceive. Third, the name includes a registered trademark. Fourth, the name includes any word or words which are offensive to a section of people. Fifth, name which is identical to or too nearly resembles the name of an existing limited liability partnership. Furthermore, statutory names such as the UN, Red Cross, or World Bank, or Amnesty International, etc., are also not allowed to be chosen. Names which in any way indicate that the company is working for the government are also not allowed. Next up is reservation of a name. Section 4, Clause 5, Subclause 1st of the Act states that for formation of the company, the registrar on receiving the required documents can reserve a name for 20 days. If the application is made by an existing company, then once the application is accepted, the name will be reserved for 60 days from the date of application. The company should get incorporated with the reserved name in these 60 days. If after making the reservation of a name, it is found that some wrong information is given, then two cases arise. First, in case the company has not been incorporated, in this case, the registrar can cancel the reservation of the name and impose a fine of rupees 1 lakh. Second, in case the company has been incorporated, in this case, after hearing the reasons of the company, the registrar has three options. These are: first, on being satisfied, he can give 3 months' time to the company to change the name by passing an ordinary resolution. Second, he can strike off the name from the ROC. Third, he can file a petition of winding up of the company. Rule 8 and 9 of the Company Incorporation Rules 2014 state that the application for reservation of name under Section 4 Clause 4 should be filed on Form INC 1. Now let's talk about the registered office clause. The registered office of a company determines its nationality and jurisdiction of courts. It's a place of residence and it is used for the purpose of all communications with the company. Section 12 of the Companies Act 2013 talks about registered office of the company. Before incorporation of the company, it is sufficient to mention only the name of the state where the company is located. But after incorporation, the company has to specify the exact location of the registered office. The company has to then get the location verified as well within 30 days of incorporation. It is mandatory for every company to fix its name and address of its registered office on the outside of every office in which the business of the company takes place. If the company is a one-person company, then one-person company should be written in brackets below the affixed name of the company. Change in place of registered office should be notified to the registrar within the prescribed time period. Next clause is Object Clause. Section 4 Clause C of the Act details the Object Clause. The Object Clause is the most important clause of MOA. It states the purpose for which the company is formed. The Object Clause contains both the main objects and matters which are necessary for achieving the stated objects, also known as incidental or ancillary objects. The stated objects must be well defined and lawful according to Section 6 Clause B of the Companies Act 2013. By limiting the scope of powers of the company, the Object Clause provides protection to shareholders and creditors and public interest. Under shareholders, the Object Clause clearly states that what operations will the company perform. This helps the shareholders know their investment in the company will be used for what purpose. For creditors, it ensures the creditors that capital is not at risk and the company is working within the limits as stated in the clause. In the public interest, the Object Clause limits the number of matters the company can deal with, thus prohibiting diversification of activities of the company. Under this comes the doctrine of ultra vires. If the company operates beyond the scope of powers stated in the Object Clause, then the action of the company will be ultra vires and thus void. Consequences of ultra vires. First, liability of directors. The directors of the company have a duty to ensure that company's capital is used for the right purpose only. If the capital is diverted for another purpose not stated in the memorandum, then the directors will be held personally liable. Second, ultra vires borrowing by the company. If a bank lends to the company for the purpose not stated in the Object Clause, then the borrowing would be ultra vires and the bank will not be able to recover the amount. Third, ultra vires lending by the company. If the company lends money for an ultra vires purpose, then the lending would be ultra vires. Fourth, void ab initio. Ultra vires acts of the company are considered void from the beginning. Fifth, injunction. Any member of the company can use the remedy of injunction to prevent the company from doing ultra vires acts. Next up is liability clause. The liability clause provides legal protection to the shareholders by protecting them from being held personally liable for the loss of the company. There are two kinds of limited liabilities. First one, limited by shares. Section 2, Clause 22 of the Companies Act 2013 defines a company limited by shares. In a company limited by shares, the shareholders only have to pay the price of the shares they have subscribed to. If for some reason they have not paid the full amount for the shares and the company winds up, then their liability will only be limited to the unpaid amount. Second is limited by guarantee. It is defined in Section 2, Clause 21 of the Companies Act 2013. A company limited by guarantee has members instead of shareholders. These members undertake to contribute to the assets of the company at the time of winding up. The members give guarantee of a fixed amount that they will be liable for. Non-profit organizations and other charities usually have a structure of companies limited by guarantee. Next up is capital clause. It states the total amount of share capital in the company and how it is divided into shares. The way the amount of capital is divided into what kind of shares. The shares can be equity shares or preference shares. Next up is the subscription clause. The subscription clause states that who are signing the memorandum. Each subscriber must state the number of shares he or she is subscribing to. The subscribers have to sign the memorandum in the presence of two witnesses. Each subscriber must subscribe to at least one share. Next up is association clause. In this clause, the subscribers to the memorandum make a declaration that they want to associate themselves to the company and form an association. Under this, Memorandum of Association for one-person company. A one-person company is called so because it can be formed by one person. The minimum capital required to form one-person company is 1 lakh rupees. It is a new concept which has been introduced to promote entrepreneurship. All the laws which are applicable on private companies will be applicable on one-person company. Section 2, Clause 62 of the Companies Act 2013 defines one-person company. A one-person company is a separate legal entity from its owner. It is mandatory for the company to be converted into a private limited company in case its annual turnover crosses the 2 crore mark. In case of one-person company, in addition to all the other clauses, the Memorandum of Association contains a clause called the nomination clause. This clause mentions the name of an individual who will become the member in case the subscriber dies or becomes incapacitated. The nominee must be an Indian citizen and resident of India. That is, he must have been living in India for at least 182 days in the preceding year. A minor cannot be a nominee. The individual whose name is mentioned should give his consent in written form, and it is required to be filed with the Registrar of Companies at the time of incorporation. If the nominee wants to withdraw, he shall give it in writing, and the owner of the company will have to nominate a new person within 15 days. So the question arises, what's the use of Memorandum of Association? Why is it needed? To explain this, I have got 5 points. First one is, it defines the scope and powers of a company beyond which the company cannot operate. Second, it regulates companies' relation with the outside world. Third, it is used in the registration process. Without it, the company cannot be incorporated. Fourth, it helps anyone who wants to enter into contractual relationship with the company to gain knowledge about the company. Fifth, it is also called the charter of the company as it contains all the details of the company, its members and their liabilities. Next up is subscription of Memorandum of Association. Subscribers are the first shareholders of the company. They are the people who agreed to come together and form the company. The name of each subscriber along with the particulars are mentioned in the memorandum. Different kinds of company require different number of subscribers for incorporation, such as private company requires 2 people, public company requires 7 or more subscribers, one person company requires only one person. So the next question arises, who all can subscribe? Rule 13 of the Companies Incorporation Rules 2014 describes the provisions of subscribing to the memorandum. There are specific kinds of persons, natural or artificial, who can subscribe to the member. These are first, individuals. An individual or a group of individuals can subscribe to the memorandum. Second, foreign citizens and NRIs. Rule 13 Clause 5 of the Companies Incorporation Rules states that for a foreign citizen to subscribe to a company in India, his or her signature, address, and proof of identity will need to be notarized. The foreign national must have visited India and should have a business visa. For a NRI, the photograph, address, and identity proof should be attested at the embassy with the certified copy of a passport. There is no requirement of business visa. Minor can only be a subscriber through his guardian. Second, company incorporated under the Companies Act. The company can be a subscriber to the memorandum. The director, officer, or employee of the company or any other person authorized by the Board of Resolution. Third, company incorporated outside India. Foreign company is defined in Section 2, Clause 42 of the Act. It states that a foreign company is a company incorporated outside India. A company registered outside India can also subscribe to the memorandum by fulfilling the additional formalities. Society registered under Societies Registration Act 1860. Fifth, LLP. A partner of a LLP can sign the memorandum with the agreement of all other partners. Sixth, body incorporated under an Act of Parliament or state legislature can also be subscriber to the memorandum. Next up is subscription to MOA. Every subscriber should sign the MOA in presence of at least two witnesses. The following particulars of the witness should also be mentioned. Firstly, the name of the witness. Second, the address. Third, the description. Fourth, the occupation. If the signature is in any other language, then an affidavit is required that declares that the signature is the actual signature of the person. According to Circular Number 858 dated in 1958, the subscriber can also authorize another person to affix the signature by granting a power of attorney to the person. The person who is granted the power of attorney may be known as an agent. He or she should also state the following particulars in the memorandum. Firstly, the name of the agent. Second, the address. Third, the description. And lastly, the occupation. Next up is particulars to be mentioned in MOA. Rule 16 of the Companies Incorporation Rules 2014 details the particulars that are to be mentioned in the memorandum. Every subscriber's following details should be mentioned. First, name includes last name and family name. A photograph should be affixed and scanned with the memorandum. Second, father's name and mother's name. Third, nationality. Fourth, date of birth. Fifth, place of birth. Sixth, qualifications. Seventh, occupation. Eighth, permanent account number. Ninth, permanent and current address. 10th, contact number. 11th, fax number, which is optional. 12th, two identity proofs in which permanent account number is mandatory. 13, residential proof not older than 2 months. 14, proof of nationality if subscriber is a foreign national. 15, if the subscriber is a current director or promoter, then his designation along with name and company identity number. If a body corporate is subscribing to the MOA, then the following particulars should be mentioned. First, corporate identity number of the company or registration number of the body corporate. Second, global location number, which is used to identify the location of the legal entity, which is optional. Third, the name of the body corporate. Fourth, the registered address of the business. Fifth, email address. In case the body corporate is a company, then a certified copy of board resolution which authorizes the subscription to the memorandum. The particulars required in this case are: first, number of shares to be subscribed by a body corporate. Second, name, designation and address of the authorized person. In case the body corporate is a limited liability partnership, the particulars required are: first, a certified copy of the resolution; second, the number of shares that the firm is subscribing to; third, the name of the authorized partner. In case the body corporate is registered outside the country, the particulars required are the copy of certificate of incorporation and the address of the registered office. Next up is printing and signing of MOA. Section 7 Clause 1 Clause Subclause A states that the Memorandum of Association should be duly signed by all the subscribers and should be in a manner prescribed by the Act. Rule 13 of the Company Incorporation Rules 2014 describes the manner in which the memorandum should be signed. First, the MOA should be signed by each subscriber to the memorandum. The subscriber shall mention his name, address, occupation, and the number of shares he or she is subscribing to. The document should be signed in the presence of at least one witness. The witness would also mention his name, address, and occupation. By signing the memorandum, the witness states that I witness to subscriber or subscribers who has or have subscribed and signed in my presence. Further, I have verified his or their identity details for their identification and satisfied myself of his or her or their identification particulars as filled in. Second, if the person subscribing to the document is illiterate, he can either authorize an agent to sign the document through power of attorney, or he can put his thumb impression on the column for signatures. The person's name, address, occupation, and the number of shares he is subscribing to should be written by a person who has been allowed to write for him. The person who is writing for the illiterate person should read and explain the contents of the document to an illiterate person. Third, where the person subscribing to the memorandum is an artificial person, that is, a body corporate, the memorandum shall be signed by the employee, officer, or any person authorized by the Board of Resolution. Fourth, where the person subscribing to the memorandum is a foreign national who does not reside in India but in a country that is in any part of the Commonwealth, his signatures and address on the memorandum and proof of identity shall be notarized by a notary public in that part of the Commonwealth, or in a country which is a signatory to the Hague Apostille Convention 1961. His signature and proof of identity and address on the memorandum shall be notarized before the notary public of the country of his origin and be duly approved in accordance with the said Hague Convention. Or in a country outside the Commonwealth and which is not a party to the Hague Apostille Convention 1961, his signatures and address on the memorandum and proof of identity shall be notarized before the notary public of such country, and the certificate of the notary public shall be authenticated by a diplomatic or consular officer empowered in this behalf under Section 3 of the Diplomatic and Consular Officers Oath and Fees Act 1948. Section 3 of the Diplomatic and Consular Officers states that every diplomat or any officer in a foreign country can perform the functions of a notary public. Firstly, where there is no diplomatic or consular officer by any of the officials mentioned in Section 6 of the Commissioners of Oaths Act 1889. Second, if the foreign national visited India and intended to incorporate a company, in such a case the incorporation shall be allowed if he is having a valid business visa. Section 15 of the Companies Act 2013 states that the memorandum should be in printed form. The Ministry of Corporate Affairs has clarified that a document printed in form laser printers will be considered valid provided it is legible and fulfills other requirements as well. The submission of Xerox copies is not allowed. The Xerox copies can be submitted to the members of the company. Next up is alteration, amendment, and change in MOA under Companies Act 2013. The term alter or alteration is defined in Section 2, Clause 3 of the Act as any additions, omissions, or substitutions. A company can alter the memorandum only to the extent as permitted by the Act. According to Section 13, the company can alter the issues in the memorandum by passing a special resolution. A resolution is a formal decision taken in a meeting. There are two kinds of resolutions, ordinary and special. A special resolution is one which requires at least two-thirds majority to be effective. The alteration to the clauses also requires the approval of the central government in writing. The alteration of memorandum can happen for a variety of reasons. The alteration can be made if, first, enables the company to carry its business more effectively. Second, helps to achieve the objectives. Third, helps the company to amalgamate with another company. Fourth, helps the company dispose of any undertaking. Under this, let's talk about alteration of memorandum. The alteration of various clauses of memorandum have different procedures. First, alteration to the name clause. To alter the name of the company, a special resolution is required. After the resolution is passed, the copy is sent to the registrar. For changing the name, the application needs to be filed in Form INC 24 with the prescribed fees. After the name is changed, a new certificate of incorporation is issued. Second, alteration to the registered office clause. The application for changing the place for registered office of the company shall be filed with the central government in Form INC 23 with the prescribed fees. If the company is changing its registered office from one to another, then the approval of the central government is required. The central government is required to dispose of the matter within 60 days and should ensure that the change of place has the consent of all the stakeholders of the company. Alteration to the object clause. To alter the object clause, a special resolution is required to be passed. The changes must be confirmed by the authority. The document which confirms the changes by authority with a printed copy of the altered memorandum should be filed with the registrar. If the company is a public company, then the alteration should be published in the newspaper where the registered office of the company is located. The changes to the object clause must also mention on the company's website. Alteration to the liability clause. The liability clause of the memorandum cannot be altered except with the written consent of all the members of the company. By altering the liability clause, the liability of the directors of the company can be made unlimited. In any case, the liability of the shareholders cannot be made unlimited. Changes in the liability clause can be made by passing a special resolution and sending a copy of the resolution to the ROC. Alteration to the capital clause. The capital clause of company can be altered by an ordinary resolution. The company can, first, increase its authorized share capital, second, convert the shares into stock, consolidate and divide all of its shares, fourth, cancel the shares which have not been subscribed to, fifth, diminish the share capital of the shares cancelled. The altered MOA should be submitted to the registrar within 30 days of passing the resolution. So that's all about today's lecture. Hope you understood and gained something out of this lecture. So do not forget subscribing to this channel for more such informative lectures, and do hit the bell icon to get notified every time I put a video lecture. Thank you.